Good morning. Today I want to discuss an important equitable remedy which has developed over the last 30 years, a little bit more, which involves the grant of an Anton Piller order, A-N-T-O-N-P-I-L-L-E-R, which is an eponymous order named after the famous case of Anton Piller and manufacturing processes, a case decided in 1976, which you can find in 1976 Chancery at page 55. And what is an Anton Piller order? Well, an Anton Piller order is an order which really operates as a civil search warrant, in the sense that it's an order made by the court requiring the party named in the order to permit a solicitor and other people to come into the premises and conduct a search for items described in the order, detailed in the schedule to the order. And what's the main use of those orders? Well, the classical situation. You might have, say, an intellectual property case. Someone is breaching copyright. You suspect they're breaching copyright. You want to enter their premises to see if there are any infringing copies on the premises. You go to the court and you apply ex parte, of course. That's to say, without giving notice to the defendant. And you get an order from the judge making full disclosure. And you then have an order which allows you to arrive at the premises and search, theoretically, but we'll cover that in a minute. Or you might have, say, a departing employee, the classical situation. Someone is working for you in the company, then they get a better offer or they decide to go somewhere else, and you then suspect that various intellectual property has been taken, either confidential information has been downloaded, there's a disk that's gone missing, something proprietorial to you is gone. So you want to get an order to see if you can find out what's happening. And this has been described as a bit of a nuclear weapon, being able to come onto someone else's premises, because of course you're impinging on their right to privacy and all sorts of things. They've got a right to keep you out. So an Anton Piller order, provided in most rules of court, allows for the court to make an order without notice to the respondent to permit the applicant or another person named in the order to enter the respondent's premises and inspect or seize documents or other items. And it may also require the respondent to disclose stated information relevant to the proceedings to which the order relates, and may have injunctive relief attached to it as well. And this is something which the court developed, as I said, as a matter of practice over a number of years. And an important case which one should have at one's fingertips is the decision of Vice-Chancellor Scott in Columbia Picture Industries and Robinson, which is a case in 1987, Chancery 38, important decision of the English Chancery Court. Now, this is an important decision because, as we'll see in a moment, most courts now have a practice note which actually sets out what you can and can't do in relation to an Anton Piller order. And the details of that practice note, in fact, follow pretty closely what the judge said in Columbia Pictures and Robinson. And if you look at what the judge said in Columbia Pictures, you'll see that his honour says that a defendant who is served with an Anton Piller order comes under an immediate obligation to consent to the plaintiff's entry onto and search the premises and removal from his premises of material specified in the order. If the defendant does not immediately give such consent, he will thereby commit a contempt of court. And that will be so even if the order is subsequently discharged because of some problem with it. Now, of course, it's very disruptive of plaintiff's business to allow such an order to occur, and there are a large number of protections which are involved in the order. And if you want to see how to make such an order, you can see, have a look, as a good example, at the Federal Court of Australia. You've got practice note number 11, CM11, which describes search orders, which are also known as Anton Piller orders. And the practice note notes that this note supplements Order 25 capital B relating to search orders, also known as Anton Piller orders, and sets out a common practice. Now, of course, an Anton Piller order, as I've said, is pretty disruptive of the defendant's business. What happens if such an order is served? Can you just barge your way in? Well, no, of course you can't. As we said just a minute ago, the nature of the order is such that it's served on you as the defendant by the applicant, and the sanction against you is that you're in contempt of court if you don't grant immediate access. But with this proviso, of course, a lot of orders run to 10, 12 pages. You're suddenly confronted by someone arriving. Each order, each standard order, will contain in it the entitlement to obtain legal advice. So if you're there and you're suddenly confronted with an Anton Piller order, someone arrives, you can simply say to them, "Gentlemen, this is a complex matter. Thank you very much for arriving. I'll make you a cup of tea. Please sit outside. I'm about to bring my legal advisors to get legal advice." Now, of course, if you're doing so, you must actually go ahead and get legal advice. And equally, you must not destroy, tamper with any evidence or do anything which is in breach of the actual order. So let's suppose you're a departing employee. You can't suddenly turn around and think, "Oh, good, I've got a 5 or 10 minutes, I'm going to burn or shred or do something with these things I've taken." Can't do that. That would be a gross contempt. But unlike a criminal search warrant issued to the police, say pursuant to section 33E of the Commonwealth Crimes Act, the people in possession of the order can't simply come in. They can't knock down doors, they can't enter with such constables as they may require, and you can't be in breach of the peace or whatever by not resisting them but closing the door on them. So it's a civil remedy, it's not a criminal, not part of the criminal process. And that's always an important thing to bear in mind. We'll come back briefly at the end to criminal matters. Alright, so Anton Piller order, it's a search order, and it instructs you to allow people to come onto your premises. But as the Federal Court Practice Note says, it's very useful to read it in detail. You're looking at an ex parte order. So the first thing, of course, with any ex parte order in the Court of Equity is that you must have made full and complete disclosure. Remember a case years ago when complete disclosure hadn't been made. The judge, when it came back, wasn't very happy at all, because if you're applying ex parte, you run the risk, if you don't make full disclosure, of having the order discharged mero motu. The court will simply discharge it as a matter of immediate action if you haven't made full disclosure, because you're there in court and you've got the first shot without anyone else being present. So you've got to make full disclosure. Secondly, under the modern practice, the order has to provide for an independent solicitor who will supervise the search, and a solicitor to represent the applicant. And it may be necessary to include other people. You might need a computer expert, someone who can identify various things. But ordinarily, the search party should not include the applicant or the applicant's directors, officers, employees or partners, or any person associated with the applicant other than the solicitor. Now you can see here an inherent problem in the Anton Piller order. Let's suppose you're seeking access for confidential information. Right? It may be a fraud business situation. You want access to the new premises where someone has set up a rival business. They've left your company, they're setting up a new rival business. So you knock on their door. If you enter, of course, as the applicant, you will then in a sense be looking at all their private and intellectual property as well. So the order tries to prevent that happening, but you'll find it's a real practical problem, of course, because by definition the person who's best able to actually recognise information or documents or whatever that may have been taken will be people in the old company. Stands to reason. So you'll have to brief the solicitor pretty well to enable that solicitor to go in and search and make a proper search, proper discovery. Now you've also got to specify the number of people who can come. You can't have an order that provides for a cricket team to turn up. Usually you'll have the independent solicitor for whom you're paying, of course, as the applicant, and you'll also have a number of people named in the order, but it's really got to be as small as is reasonably practicable. Alright, and you've got to set out the various people, and you should actually describe who the people are if you can do so. The affidavit which you're using, ex parte, must set out the description of the things that you're looking for, the address of the premises which you're going to search, why the order is sought, and including why there is a real possibility that the things to be searched for will be destroyed or otherwise made unavailable for use in evidence before the court. That point's a vital one, of course. You're really getting this peremptory ex parte order because you fear possible destruction of documents or other evidence which is vital for your case. So if you can't demonstrate that, then you've got to proceed in the usual way. And on the other side, parties, of course, are obliged to make proper discovery and hand over documents or whatever else may be required under the usual process of the court. So it's the fact that something may be destroyed which is the key factor. If you can't show that, the duty judge won't give you an order. You've also got to show what prejudice, loss or damage may be suffered if the order is not made. And as I've already said, the name, address and firm of an independent solicitor who consents to being appointed to serve the order supervise its execution, and do such other things as the court considers appropriate. Now, qualifications. If the premises are residential premises and or you feel that a woman may be present, or a child under the age of 18, or any other vulnerable person, you've got to tell the court that. The court doesn't like people turning up at people's houses, for example. If you're going to search an office where you've got women present, you've got to have female solicitors who are going to turn up to conduct the search. You can't have women working in an office confronted by a large number of fellas turning up. That's not allowed under the order, and quite appropriately. So you can see there are a number of things which hedge about exactly what you can do in the order. If you envisage having a specialised computer expertise, then you'll need to make specialist provision, and you'll need to have an independent computer expert who is going to give various undertakings to the court about what he or she will or won't do with the information discovered when they're looking at the material which they're finding. Now, Federal Court order notes that the independent solicitor is an important safeguard against abuse of the order. The independent solicitor mustn't be a member of the applicant's firm of solicitors, must be experienced in commercial litigation, preferably in the execution of search orders. Law Society has to have a list of solicitors who are available to carry out search. And what are they? Well, the duties of the independent solicitor include service of the order, an application for it, and the affidavits relied on. They have to be able to offer to explain the items in the search order and explain that the respondent has the right to obtain legal advice and supervise the carrying out of the order. And most importantly, before removing things, make a list of them. Allow the respondent an opportunity to check, sign the list and provide parties with a copy. So naturally, if you're taking something away that's in someone's private premises, you need to provide a detailed inventory. And before this was codified, a famous case, long and specified publications, Justice Bryson, I think it was, in 1987, fined someone about $20,000, which is not a small fine by anyone's reckoning, for failure to carry out the various undertakings which they'd given to make sure that inventories and various other things were compiled. If you give an undertaking to the court and you're in breach of it, you're in contempt yourself. So, independent solicitor also must take custody of all things removed and safeguard them, and submit a written report to the court within the time prescribed by the order as to the execution of the order, and attend the return date of the application and be available then to bring back to the court all the things which have been removed. Now, ordinarily, the applicant is not permitted without leave of the court to inspect things removed from the premises or copies of them, or be given any information about them by members of the search party. And usually, if it's a business day, you've got to act between 9 and 2 p.m. Equally, you can't turn up with the police if they're executing a warrant or some other regulator is, perhaps the tax office, and enter it when they're searching. You can't do that. And as I've already said, if you think there'll be a woman, female present, or a child under 18, then independent solicitor should be a woman, and the search party must include a woman. And so you've got to think ahead about who is likely to be present. Then on the return date, matter comes back, and when it does come back, which of course will then be an inter partes hearing, the court will consider the following issues: what's to happen to the various material removed, how can commercial confidentiality of the respondent be maintained, look at any question of legal, professional or other privilege, and any other issue which is raised by a party. And as I've already said, undertakings are required as to damages when you're going ahead to get this particular order, and the solicitor will need to get released from those undertakings, I suppose, after the order is properly executed. No, so it's a pretty useful sort of order, and the order should be served and endorsed with a notice to meet the requirements of UCPR Part 40 Rule 7, Victoria Supreme Court Order 66 Rule 10, Federal Court Order 37 Rule 2. Alright, so an order made by Chief Judge Black, 2009, with sample orders attached, and that's really the way to proceed. So, looking at it practically, someone knocks on your door, they're there with an order, they've got a supervising solicitor. Do you need to immediately give them access? Well, we've already seen, you don't have to. Supervising solicitor will tell you you can wait and get legal advice. Often the advice may be apply straight to the court to discharge the order. I did that on one occasion. my clients were there waiting and someone turned up with an order. They said, what can we do? I said, make them a cup of tea, be polite, close the door, you're not committing any contempt, you're getting legal advice, and tell them I'm applying to a duty judge, who was Mr. Justice Hodson, and now late Justice Hodson, David Hodson, what a great judge. Went straight up to court at 10 o'clock. They'd arrived about 9 o'clock, and this is a danger, of course. If you're there for the applicant, it will have cost you a lot of money to get the Anton Piller order, because you'll have reams of affidavits and whatever. You should always make sure, I think, if you're solicitors, that you've got junior counsel available to go to court when you serve the order. Because in this particular case, without telling you too many old war stories, the other side only had solicitors. Of course, I was a barrister in Equity Division, well used to fighting cases, and I went straight up, and Justice Hodson looked askance at the order. This is a long time ago. The order wasn't in any common form under the new rules, as the case in 2002. He just tore into the order, and eventually we gave undertakings, and the whole matter was resolved without even letting them on the premises. We undertook to deliver matters up to them. So, if you're going to use the order, it's like a Pearl Harbor nuclear option. You're turning up, you've still got to be ready to go to court. Don't expect that people will simply roll over and let you in. They may not do so. And they're well within their rights. If it's a complex order, the case law tells us, you might take any amount of time to look at the order to get legal advice. It might take you 1, 2, 3 or 4 hours, during which time, of course, everyone else is simply cooling their heels. All right, now what if you've got, by way of contrast, to an Anton Piller order, a search warrant issued under Section 3, capital E of the Commonwealth Crimes Act? Excuse me. Well, if that happens, completely different ball game, of course. If police turn up, federal agents with warrants, or the state police, you need to act promptly, but you won't be able to stop them coming in. They will simply be able to enter, and indeed if you prevent them from entering, they'll arrest you for impeding them in the execution of their duty. And I think the old Storm of Warrant probably still says they can break down doors and pretty much do what they like without causing too much mayhem. So what can you do in that situation? Well, in that situation your scope is more limited, but don't forget, in that situation you've got one avenue of judicial review. If someone enters with a Commonwealth Crimes Act warrant, for example, then that was an administrative decision which is made under an enactment and will attract the operation of the ADJR Act, Administrative Decisions Judicial Review Act. You won't be able to stop the police, but you might be able to get them to give you an undertaking. They won't look at anything if you apply immediately to the court. And if you apply immediately to the court under Section 5 of the ADJR Act, you'll need to set out all the grounds as to why you think the warrant is invalid. You'll say, well, no basis for it, it's irrational, etc., etc. All the grounds in Section 5(1) of that Act might be available. One possible ground with the police, I suppose, is that things are subject to legal professional privilege. And we saw a recent example of that where Channel 7, I think it was, and its legal advisors were raided. You probably saw that in the newspaper, Channel 7, and other legal advisors were named in a warrant. I don't know how that happened. They were alleged to have committed some offence. Didn't seem very likely. It wasn't at all possible, but obviously a bad mistake with the warrant, whoever drafted it. And they have gone to court and they've quashed that warrant, and it's all been thrown out, and the whole matter has been resolved to their satisfaction. So, big difference, of course. Civil search warrant, in a sense, an Anton Piller order, you've got an option. You can ask people to wait. They can't enter as of right. You can tell them to wait. You're getting legal advice, and then you can get some advice and proceed. On the other hand, if it's a criminal warrant, criminal search warrant issued under the Crimes Act or the state legislation, then the police can enter peremptorily. They don't need to wait. They can arrest you if you just try and stop them. So you've got to be pretty fleet of foot to get into court to seek some sort of remedy, and that'll have to be a judicial review remedy of the warrant. So an Anton Piller order, a very valuable supplement, I suppose, to the armoury of those who need to seek advice or advising in particularly intellectual property cases, as I said, breach of copyright, and also in a situation where an employee has left. That's where it's usually used. You think someone has left and taken away something from your premises, and you then want to search, and usually, of course, you'll be seeking other relief as well. You might seek an injunction to stop them working. There might be some restraint of trade or some covenant, something like that. So have a look at that remedy. It's a remedy that's been around since 1976, so we're coming up to the 40-year mark for it. Lots of cases on it. If you're issuing one, of course, there'll be an expert solicitor who will know all about it in the office, no doubt, but have a good look at the practice note. that's what you need to consider, and that will detail what you need to demonstrate, what you need to prove. So a useful remedy, and my next seminar, next video, I'll discuss Mariva injunctions, which is also a remedy developed in equity to assist applicants.